Right, exactly. So he demonstrated candor. And in addition to being persuasive, it's also required by the rules of professional conduct, and the court points that out, that Rule 3.3 of the model rules, and New York Rule 3.3 is exactly the same, requires that a lawyer shall not knowingly fail to disclose to the tribunal controlling legal authority known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. And he came forth with evidence that what? Or not evidence, but information that what?
That this defendant should only be charged with a single violation instead of multiple violations.
Right, but here the number of victims, that each victim does not constitute a separate violation if it's a single continuous act. And so so the prosecutor brought that information forward and let the judge know that, and the judge dismissed one of those counts and sent it back to the trial court to discharge his sentence on that one count. Did anybody notice what the sentences were on each count? Yeah, Dominic?
I think there were 30 years each.
Yeah, there were 30 years each. Now, it doesn't say whether they were running concurrently or consecutively. My guess is that they were going to run concurrently anyway. And so this is one of those instances where, and I'm not saying the prosecutor wouldn't have done it otherwise, because they may very well have been consecutive sentences. But this is one of those situations where you have to know what you can concede. It doesn't hurt the prosecutor to concede one of those counts, because the likelihood is that they were concurrent sentences anyway, and so they were going to run together at the same time. And so 30 years running at the same time is 30 years, whether there's 2 concurrent sentences or 40 of them. Now, the difference is, that makes a difference. It makes a difference when it's time for parole, whether you've got 4 concurrent 30-year sentences or 1 30-year sentence. But it may not actually have hurt that much in the long run. Nevertheless, it helped a tremendous amount. Maybe not with this particular case, but if you look at the long game, as the prosecutor here surely was, it does make a huge difference to the prosecutor's reputation with the court. So this is one of the ways that that we demonstrate candor, is to, and to me, this is so awesome, because you have to do it anyway. You know, it's sort of like getting extra credit at law school for just showing up. Everybody who shows up gets extra credit today. Well, you have to show up anyway. So he had to disclose that anyway, but it really does pay off dividends. Does anybody have any questions? Okay, so we're going to finish up today our discussion of ethos in legal writing, and specifically intelligence as a trait of legal writing. And we're going to do that 2 ways. One is that you guys are going to discuss the traits of intelligence that you demonstrated in your brief. And so you guys are going to get into your groups, and you're going to talk with each other about the way that you believe your brief demonstrated intelligence. And you're going to give examples, the way the essay sample for 8.8 did. So that's just going to require that you identify what the trait is, and then maybe read out a sentence that indicates that trait, or describe what it was you were doing that indicates that trait. It will probably be handy to have the book or your notes nearby to refer to specifically the 10 traits of intelligence as you go through. And then after you guys do that, we'll come back together and talk all together about what you guys discovered in your briefs, and any questions that you have about the trait of intelligence. And just like at the end of Monday's class, you guys then had the information you needed to start looking for priming examples in your writing. Now, after today's class, you're going to have a lot of information about where to find the examples of ethos in your writing, or maybe where you are missing some ethos. Maybe your citations need to be cleaned up. Maybe the basic writing needs to be cleaned up. Maybe you've got a lot of string cites, and that indicates that you had trouble discerning which authority to use. So you'll have a lot of information to sort of move to the next step on your appellate brief final project. My strong recommendation is that as we cover each of these strategies, do that part of your brief, at least go through and make notes about it, so that that's the easiest way to make sure that you get each of these strategies represented in the final project. So you can do this a little piece at a time and then have sort of a big cleanup push at the end. Okay, so let me tell you the groups we're going to be in. Okay, so Greiner, Kalderoff, and Smith, you guys are going to be together. You guys all are on the House versus Kegs list brief, except for Randy, who's on the Archer versus Food Joint, but both of those are ADA compliance issues. And so you guys don't have to learn a lot of new law. So the first thing that you want to do when you get into your groups, you guys specifically, is summarize briefly what your issues are about, and then you can start talking about where you found intelligence in your briefs. The next group is Rossi, Spencer, and Broderick. Rossi and Spencer, you guys have the Smith versus Eastview, and Broderick, you can take this as a compliment, and maybe that will make this go down a little bit easier. You're going to be with them because I've got too many people on the Silverman versus Rafel thing, and theirs is going to be something that you've already covered in other classes, their issues, and so you'll be able to get up to speed on that pretty quickly. And then Marilyn and Nicole, Ryan is very adept at describing his issue as evidenced by the paragraphs that he wrote, and so he'll be able to explain to you what his issue is, so you guys can help each other out. I think there are advantages both ways. I think there are advantages to having a group where everybody's working on the same issue, and then I also think there are advantages to being in a group where everybody, or maybe some people, are working on different issues, because you come at it from kind of different perspectives. So I think there are pros and cons of both. Okay, the next group is Nick, Joan, Ken, and Sean. You guys are all on the Molson brief. Nick and Joan represent the plaintiff, and Ken and Sean represented the defendant. So you guys can work together on that one. Lorraine, Jackie, and Mila, you guys are going to be together. You're on the House versus Kegs list. Lorraine and Jackie are plaintiffs, and Mila was a defendant. Loretta, Nikki Sorrentino, and Karina Bandy, you're all on different issues. I don't know what Karina's issue is, so you guys will have to talk about that. And Karina, you'll get me your descriptive paragraph. Great. But Loretta and Nikki, I know, have similar issues, which were First Amendment issues in a school setting. So you guys are looking at a very similar body of law. The next one, the final group, is Yusun, Dominic, and Rayanne. You guys are all on the Silverman versus Rafel case. So I'm going to put you in those groups. It's going to take me just a second to sort you guys out specifically. Manually, 1, 2, 3, 4, 5, 6. Oh, before I... Okay. Oh, I see what happened. Because Joan's not here, the numbers are a little bit off. Okay, so here's one more thing. In each group, you're going to have roles so as to make sure that everybody participates and everybody's active and nobody sits back. So the roles that are available are discussion leader, reporter, and recorder. I don't care who does what role. You guys work that out at the beginning. The discussion leader is the one who's going to keep you guys on task and move things forward and make sure that you're productive. The recorder is the person who's going to take the notes for the group. And then the reporter is going to be the spokesperson for the group when we come back together. And you will let us know what the group had to say. So those are the three roles: discussion leader, recorder, and reporter. So you want somebody very good at note-taking to be the recorder, somebody good at speaking, somebody very comfortable speaking to be the reporter, and then somebody who's going to be organized and task-oriented to be the discussion leader. Okay, so let me see about creating your rooms. Breakout room 1, assign. Yay. Does anybody have any questions before you guys go into your rooms? Yeah, Loretta?
If you're recording, is that something you're going to type up and hand in?
Oh, no, no, no. It's just so that your reporter has notes.
Okay.
Yeah.
Okay.
It's just to make sure you get everything down. So somebody who's good at note-taking, somebody who's good at sort of synthesizing information and putting that together for the reporter. Next time we do this, it'll be easier because you guys will already be in there. And all right. Whenever you guys are done going through talking about, for those of you who have different problems, give each other a brief synopsis of the problems, and then start talking about where you found intelligence, and give each other some feedback on whether, you know, when somebody identifies a trait of intelligence in their writing and gives an example, if you don't think that that is that trait of intelligence, but you think maybe it's a different trait of intelligence, or you think it's a trait instead of character or goodwill or something different entirely, give each other feedback, help each other work through these issues. Okay, I'm going to send you to your rooms. Come back when you're done. Okay. Where? That is an interesting problem I just created. Because I've had people leave the room before and I can just assign them to another room. Does it say at the bottom that you can, does it say join breakout room?
It does say join breakout room. Do you want me to do it?
No, just go ahead and go back in there and you guys can stay together tonight.
Okay,
And then I'll just swap you next time.
that's fine.
Okay, thanks.
You're welcome.
You guys all set? You guys finished?
Yeah. We didn't really have to go through all of the facts because we all had the same brief, so that was good. So we kind of just jumped right into it.
Yeah, that's fantastic.
I'm actually not the reporter, though.
Okay.
But I don't know. Do you want us to report right now?
No. Wait till everybody gets back.
Oh, yeah, because we weren't sure what was going on because we kind of finished. We talked about the bad brief, too.
Oh, really?
Yeah.
Oh, you guys are all over it. That's fantastic.
Yeah. So, I don't know. Should I just wait in the – oh, yeah, here they are.
Here they are.
What's up?
Hey, guys.
How's it going?
So we're just waiting for everybody to get back. So do you guys have any questions about anything?
Not really.
Yeah, I don't think so.
We all kind of agree with what what we all could have done, considering we knew the facts and everything.
Right, yeah, that speeds things along because there's one group where every single person is doing a different brief.
Oh, that's tough.
So yeah, so it's going to take them a little bit longer.
Yeah, us it was pretty easy because we all knew the facts, same cases,
Yeah.
And I don't know. Most part, I kind of took this class for a lot of the reasons what we discussed.
Mm-hmm.
To improve my writing and be a little more persuasive.
Yeah.
So.
This, once you start rewriting this, that's when you're going to start to notice things. You'll start to notice your writing starting to get better because the goal isn't to write better first drafts. The goal is to write better final drafts. And the way that you do that is to learn how to revise your own stuff and to kind of have a checklist in your head to know what it is that you're looking for and to sort of strategize, more than just the organization, but to strategize sort of the persuasiveness and stuff like that.
I had a quick question. So I remember you said we need to hand in we'll redo 6 parts of the brief, right?
Yes.
So, and you were talking about how some of us had summary of the case and other ones had summary of the facts or something
yeah, it depends. What was...
I think we had a statement of the case.
Okay, and that's where your facts were. Did you do it under state rules or federal rules?
We were in federal.
Oh, okay, yeah. So the statement of the case...
It had a procedural history in it.
Yeah, because that's what the federal rules require. That's what my students had that too with the procedural history. And one of the things to keep in mind is, and you'll see this as we get a little bit further in, is that you can actually make the procedural history persuasive. That it's not just the...
Yeah, I think actually Professor Pocock discussed that with us.
Yeah.
She was saying how since mine and Sean's side, we won the motion.
Right.
So she said to definitely highlight that in your procedural history.
Yeah, and not only that, since you won it, you also want to go into a little bit more detail in the procedural history about what the grounds were, what the court used as the basis for its decision, so that you give a little bit more detail about the winning, so that the winning takes up more space. Whereas when you lose the underlying motion, you just want to say that you lost. You don't want to go into a lot of detail about why you lost, and so you'll provide a little bit less detail about stuff like that. It's so funny because as I was looking at these briefs, because I recognize them from who assigned the different ones. Let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9. Over half of you were in Professor Pocock's class, either this year, last year, or the year before.
Wow.
I know. I thought that was so funny.
She had an impact on us.
Yeah, and I don't know who. I know I had Ryan and Nikki Sorrentino, and then I'm not sure who the other ones were. Smith versus Eastview I think that may have been the group. There are several professors who usually work together on an appellate brief problem, and I think that might have been theirs. What did you guys notice, if anything, did you notice was missing from your briefs, from that one argument section you looked at?
The biggest thing with me, what's missing from my brief, I don't think I put enough counter arguments.
Okay.
I think that was my weakest point. That I probably could have done more
Okay.
of, or just being more organized. I don't know. I really struggled with the whole 16-page limit and like trying to like just squeeze it all in there.
Mm-hmm.
You know, I think make better use of my space.
Mm-hmm. Yeah, it's tough. The first place you want to look to pick up space to use for content is editing, and we'll talk about that next week. But you can pick up a lot of space just editing, not even touching the content.
Yeah.
And then once you've tried that, then you start thinking about, okay, what am I going to include? Now, of course, in legal process, you don't have a choice. You're told what issues to include, and you kind of, you know, there's a set of expected arguments that you'll make. But in this class, not necessarily. I mean, if you can justify strategically taking an issue out, so that you can have more space for another issue, as long as you can justify it and it makes sense, you can do that. Although you don't have a page limit now.
I think one thing that me and Nick talked about, like after reading part of our summary, we didn't really like look at it in a public employee aspect. Like we just were subjective and just looked at Mr. Molson's case. You know, like we didn't think of it in a broader situation, like any employee in any situation.
Yeah, having like a big public policy argument. Like I totally missed that point, and I felt like it was definitely necessary to have looking back.
Okay. How about you guys? Randy, who did you have for legal process?
I had a Professor Shane.
Oh, that's right. I couldn't remember who. I had some people last summer who did Archer versus Food Joint, and I couldn't remember whose problem that was. Now, you represent Archer. Was he the appellant or the appellee?
He was the appellant.
Okay.
Yes, he was the appellant.
Okay. So one thing I'll do now that I've got you guys in your groups, that took a lot longer this afternoon than I thought it was going to, but I'll post on Twin, like your groups, what the cases are that you're discussing in your groups, who's discussing, you know, which position, and also your synopses that you submitted, because, you know, we looked at those two briefs on that one case in the Court of Appeals, and the bad one looked so much better beside the good one. I mean, so much worse beside the good one, and the good one looks so much better beside the bad one. And so it's not just how the brief looks in isolation, but how it looks comparatively. And so I think it's useful for you guys to start to get a sense of sort of what your peer competition is. Not that there's a curve or anything in this class, but I'd be lying if I didn't say that my view of what the best thing is influenced by like a comparison. And so I'll share those summaries with everybody so that, you know, if you look at it and you're like, hey, I'm doing pretty good. Or you may look at it and say, wow, I really need to up my game a little bit. So that'll help, I think. I think that's one thing that's missing. You know, I've struggled with how to include that in legal process. More sort of, I guess peer review, but not really in class necessarily, outside of class, because I think most first-year students feel like they're doing pretty good until they see other people's work product, and they're like, oh, wait a minute, no, I can do better, hold on. So by this point in the game, though, you guys have a pretty good sense of what the competition looks like. Randy, what did you guys notice? What traits of intelligence did you guys notice?
Well, for me, for me, Greg and Stan, the first thing that we definitely notice is just, I think from the obvious, definitely was detail orientated. No typos, following the proper format.
Mhm.
Next, it was strongly organized. There were some examples, especially with Stan, where he was able to organize the actual law in a way that was more easily able to be read. There was definitely a lot of good legal research. Both our instructors taught us that to have good persuasive arguments and to have a good mandatory legal argument. So those were things that we noticed just off the top from just reading everybody's papers. But things that really stuck out that I think you were probably more interested in a little bit is I saw a lot of examples, especially with stance, where you're able to add a carefully balanced argument to where he was considering both arguments, both pros and the cons to it. Also, there was another example, I believe, of Greg, in terms of he was able to use a lot of the analytical intelligence trait in terms of something to the point of a close reading, showing that he actually recognizes how complex the argument is. So there was an example of that. And I had a pretty decent example, I think, of the intelligence trait of practicality, something that's practical in terms of a public policy that is obvious in terms of, for my argument, in terms of the word reassignment. I made the argument that reassignment must mean that you would give my plaintiff the vacant position, because if that's not what it means, then there's no reason to even call it a reassignment. So I used that practical trait, and those were things that I noticed stood out.
Yeah, that's great. Okay, so let me go zap everybody back from the rooms. Okay. 2 more breakout rooms to close.
Oh, got it.
I think we're missing one person.
Karina just stepped away for a moment. Maybe that was it.
Okay. So, which group's reporter would like to go first and talk about what you guys noticed and what you talked about?
I could go first.
Well, I think Rayanne beat you to it. Oh, hold on just a second. Hold on. I think your son is stuck. Okay. So Rayanne, go ahead.
Okay. So you just want me to go through each of the papers and what we kind of talked about, or what was the primary issues on each of them?
You're the reporter.
Okay. So we went through my paper first, and what we did is we emailed each other's paper. We looked at it. We kind of spoke about what was personally what I felt I did well on and what I did poorly on. And then Dominic and Yusan both either agree with what I said or had some. My dog just took my earbud out. Or they didn't agree with. So it was a combination of it was kind of me saying what I felt like I did wrong and what I would like to do better, and then what they felt that I could do better. Then personally for mine, I think it was mostly grammar and articulating in that intelligence trait, which I had a little bit of a hard time with. And then Dominic's paper was next. We went through that. He explained his and what he did well and what he didn't feel like he did well. And I believe with him as well, he felt like articulation was a little bit lacking in some areas. And then for that he didn't feel like he addressed the opposing side as well. So that's something that he wanted to work on. And then Yusan was the last paper that we reviewed. I personally felt that her writing was very eloquent. It was very, I wish I had some of the writing skills that she had when it came to writing. And of course, she critiqued herself and feeling that she didn't address certain approaches the way she should have. I think both Dominic and I said that when remaining neutral in an appellate brief, it's kind of at that hard point where you're might not be expressing your sides enough and fighting enough for your side, and there's like this convoluted issue that goes on because you need to make sure you're a little bit affirmative, but you want to make sure you're addressing the other side, which I think is something that all three of us also want to make sure that we're working on as well. So,
okay. So let me ask you this: do you view, or did you view your briefs differently, having some distance in time from them? Because I mean, everybody's had at least a couple of months. And some of you have had a year or more since you wrote the brief. Having gotten some distance in time and having talked about what we've talked about with theory of the case, with authorship and audience, with ethos, are you starting to see your own writing differently?
I think because we're looking at it from the ethos perspective as of right now, it's actually very interesting because I think each of us were looking at whether we were intelligent in how we were giving, how we were telling our story in our brief, or showing our side and how it would win, and whether we had good character in doing that, and that we were doing it with goodwill. We were doing it in a way where we'd address both sides, but not seeming like they have a snarky attitude, which is what you mentioned in one of the briefs that you showed us, that there's a certain point where you can be snarky, and if it gets to a point beyond that, then you're just making yourself look not as great of an attorney. But I think we all kind of saw the critiques on it, whereas when we submit it, we're like, oh yeah, this is good. This is good enough to get the grade that we really need. It's always
great, man. The night before, it looks awesome. The night before, it looks awesome. So one of the things that we're doing in judicial writing is we're looking at sort of good and bad, not bad necessarily, but not as effective opinions. And there is a particular justice that I'm using for the good opinions because NYU Law School has put together a website on his opinions, and that's the Supreme Court nominee, Merrick Garland. Merrick Garland is and I don't have any, I know very little about him. I want to be very clear about this, that I'm not pushing an agenda, but the opinions I've read of Merrick Garland, and this seems to be the consensus about him, he's a really good writer. He's a very good writer. I wouldn't say he's a beautiful writer. It doesn't make me all warm and fuzzy inside, but it's very clear. It's very concise. And one of the things that we talk about in judicial writing is the fact that judges persuade too, that judges have constituencies, and that judges have a need to persuade, and that judges sometimes, start with the result and then support it with the opinion, rather than what we'd like to think they all do, which is, work through the whole thing, and then whatever the answer is the answer, and that's what they present. But the thing about judges that's similar to advocates is you can't seem to be persuading. Once you have been caught persuading, you're busted. It's over. You're no longer persuasive. From there on out, you're just manipulative. And it's the same way with judges. And so I really encourage you guys, if you want to see some good neutral looking writing, it's not neutral writing, it's neutral looking writing. And we may take a look at it as we get into facts and analysis later in the semester. but it's the Merrick Garland Project. And I think the website is just www.merrickgarlandproject.com or maybe .org. And it's a project of NYU Law School. And they're broken down by, criminal, constitutional. And so they're really good. They're really good opinions. If you really want to look at something that seems neutral, that really ties up all the loose ends, that undercuts the opposing arguments, and just seems to be very sort of like it's just laying it out and getting to the conclusion. Yeah, Lorraine?
How do you spell Merrick? Is it Merrick?
Merrick.
Perfect. Thank you.
Yeah, Merrick Garland. Really good writer. If you want if you want a modern judge to study for writing, you could do a lot worse than Merrick Garland. He's got a lot of good examples. Okay, who wants to go next? Randy. You're still mute.
Yeah. Me and my friends, Stan and Greg, we exchanged papers via email, and we also talked about our papers as we were all looking at the papers. The first thing that we noticed from the start was all the papers were pretty much detail orientated. We observed not too many typos on our papers. The citations were pretty much spot on. Also, it was properly organized too. I know my professor at the time, and I think even Stan told me his professor at the time really emphasized organizing the law and fact in a clear and concise way. So that was something that we noticed in all our papers. There was pretty strong legal research. There was good mandatory legal authority and some pretty good persuasive authority too. Those were the three things in terms of intelligence traits that we really noticed just from the start. As we started looking more and more in our papers, we started trying to pull out some examples of when we used practical traits and a little bit of analytical and also a little bit of empathetic traits. One good example that we use was, I believe Stan had a good example of when he used a good trait in terms of he was able to write something to the effect that after careful consideration, he actually threw that in one of his sentences. So I think he picked up where he could have used that trait. Greg also had a good example of a public policy standpoint trait in terms of me and him. If we were using the word reassignment for the ADA law, reassignment to us didn't just mean that it was an option for an employer to choose if he wanted to reassign one of his employees. It was considered mandatory. So for us, that was a good example of the intelligence trait of being practical. Mm-hmm. It was more of a public policy when Congress wrote that section of the law. So I think that was a good example that we also used. In terms of being a little bit analytical, another good example would be when there was a section in one of the papers that I actually used. I'm just going to read it out to you. Excuse me. This section was an example of being informed. Mm-hmm. The informed character trait, if I'm not mistaken. I wrote, those against mandatory reassignment argue that reassignment causes an extreme and needless business interruption for employers. So we thought that was a good example of us showing that we understood both sides of the argument, not just ours. Mm-hmm. We were able to extract that out of it.
Okay, that's great. That's great. Who wants to go next?
I'll go next.
Oh, hold on. Jackie had her hand up. Jackie, go ahead.
Okay. I guess we didn't go the route of sending each other our papers. We kind of just talked about what we saw looking it over. as far as what you were saying before we started, Professor, I definitely noticed in my paper how rudimentary it was. Like very, it wasn't, I didn't hit like the notes of the, what is it, how it was like detail oriented or eloquent. I think that's something that we all noticed as we were in our first year. We were kind of more geared towards the legal research and incorporating the case law.
Mm-hmm.
For that reason, like we had strength in that area and not so much emphasis on having flowery language or adding unnecessary fluff into the sentences that we were using. I think Mila had brought up some good points that she had actually gone further than the law that we were provided. So she went from the statute that was the issue in the case and kind of went towards the history and the statutes that came before it to kind of inform herself. And like we all kind of noticed that we organized our papers in the same way, hitting the same points because we did have the same problem. And Lorraine noticed that she had actually she tried to be, she was being persuasive, not in the way of of kind of using emphasis on the plaintiff and the poor plaintiff, but rather saying that these are the cases that are, if you judge rule in such a way, these negative things will be the result. Mm-hmm. So I think kind of all noticed that as far as priming, we all went towards more of a door in the face maneuver and showing that this will be the negative and you should agree with us because of all of these positive reasons. Yeah, that's pretty much it.
That's fantastic. Who wants to go next?
I'll go next.
Yeah, Nikki. Got to raise that hand, man.
So we went the route of not emailing each other either. So what we did was we read excerpts from it, which I thought was kind of interesting too, because when you're reading your paper out loud, it was very different than reading it to yourself. So there's a couple of things, like we all had a few things in common. We agree that we were organized and we each had the pinpoint headings and the formatting, and we had the similar thing that we were each detail oriented and we had the relevant facts in all the correct places. What seemed interesting is that the three of us failed to have any empathy with the reader throughout the sections that we went to.
How so?
And we all felt that as a common comment between the three of us is that a lot of these traits were not throughout our writing at all. And it was analytical. I mean, we were able to discuss the relevant law and both sides of the argument. And
right.
I think it was consistent with the three of us that we were able to take cases and show contrast and comparison, but it seemed across the board that we were missing some of these elements of ethos. And it was, I can't remember, like one of the students, it was like, maybe it was you, Jackie, that was saying that it just seemed a bit rudimentary, and that's kind of how we felt. So I also think it was interesting because when I was going through mine, I didn't feel that I had any section that might have been empathetic, and to hear Loretta say that maybe the one section I did wasn't just detail oriented, but it actually could have maybe appealed to the reader. So hearing somebody else's thought on something that I didn't see was helpful. But I think for the most part, we had the standard, organization and adept at legal research. We were missing some articulation, eloquence, and a lot of the advanced persuasion.
Okay, that's great. And one of the chief benefits, I mean, it is lovely to have someone tell you, oh my God, that's awesome. But it is really helpful. And there's a quote from Anne Lamott that I'll dig out for you guys for next time. It is really incredibly helpful and pretty rare to have a reader who's on the same page that you are, who knows what you're trying to achieve and can give you feedback on whether you're achieving it. Likewise, and that's, for the criticism, but likewise, it's also good because, we're not very objective critics of our work, and we tend to see it. People either tend to see their work as far, far better than it is or far, far worse than it is, depending on, just sort of personality type. And so it is also good sometimes to have somebody not just say that it's good, but to know enough about what you're trying to achieve to explain to you why it's good. Here's why this works, and here's why this other thing doesn't. And so one of the things that I always recommend to students at the end of this course is to, keep in touch professionally at least, because there aren't that many people who cover this kind of material in law school, which means there aren't that many lawyers out there who know what you're trying to do when you're trying to use these tools. And so knowing each other and having each other as professional allies can be really huge. It can be just a tremendous advantage. And so I always recommend, at a very minimum, make sure that you're hooked up on LinkedIn, and endorse each other. People, for good or ill, Career Services swears to me that employers will look you up on LinkedIn and they'll look for, what you're endorsed for and who's endorsing you. And so you guys can be tremendous assets to one another. Okay, who's next? Who's next? Who hasn't gone?
I haven't gone.
Which
But
one?
I can't raise my hand off my phone, sorry.
Oh, is that you, Sean?
Yeah.
Okay.
It was me, Ken, and Nick, and then it was a little easier for us because we didn't have to exchange papers because we've all had the same case and the same facts, so kind of just jumped right into it. All of us felt that we could have been more deliberately better, within regards to arguing the other sides and the counter arguments. I felt that was definitely my weakest. Even when I handed in my brief, I kind of didn't feel confident about my counter arguments, and they agreed with that. Just addressing the other side and maybe strategically addressing it where it helps you, if you could attack it a certain way. And then Ken brought up a good point about being more informed, instead of constantly referring to the exhibit, you could have phrased it where we said based on thorough review of the record, or some kind of wording along that way. I think we all pretty much admitted to struggling with proper word terminology in our papers. We could have been more eloquent with our style. And then citations, just cleaning them up, making sure they were spot on, or enhancing them.
Okay, that's fantastic. So has everybody gone now? Oh, very good. Yeah, Marilyn.
Okay, we screen shared our sections that we chose. It was
fancy.
Yeah, with you, right? Could do that. It was Nicole, myself, and Ryan. Nicole and I had the same issue, the same, and Ryan had something different. We noticed that none of us had any highlighting techniques in our papers, and that's one of our goals that we put down, that we would like to use that technique, not overused, but scattered here and there. Ryan's was he was really articulate throughout his section. He knew the law really well, very organized, analytical, and he showed that he was adept at research. It was quite good, and we thought he was empathetic toward the reader too, because of the way he explained in really simple language some of the law and some of the case law. And let's see, Nicole, most of her argument was public policy, so she used a trait of practicality really well, and but we thought that she could do more with organization and breaking down the sections and being a little more empathetic as far as putting headings. And let's see, as for me, I I had a goal of being really analytical. I actually use priming, foot in the door, by using Supreme Court authority first, and then going into some other things later. And let's see. And I was adept at legal research, through all the cases I went through. And so I think overall, I'm not sure if we critiqued each other, but we had more to say that was complimentary. So I don't know how helpful it was.
No, I mean that can be really helpful too. But yeah, it's also good to start to develop the ability to critique a colleague in a way that's meaningful and compassionate, and that's one of the things that you'll develop over time. Several of you mentioned citations, and several of you mentioned things like grammar and conciseness. I'm doing a CLE in I think a couple of weeks, and it's called Power Writing, and it's for lawyers. And I'm trying to think of how to get that to you guys. And so I probably need to contact the coordinator and see if I can screen record it maybe, so that you guys, because clearly I don't want you to pay for a CLE in the middle of paying for a class. So I want to see if I can screen record it. I think, if I remember my contract, that I can have a recording for my own use with my students, and so I'll double check that. If that's not the case, I can always, when I finish the CLE, because it's online, when I finish the CLE, I can always just do it again on my computer and screen record it then. So if I have to do it twice, I'll do it twice. But it's a revision technique to help you clean up the basic writing. I can also, if there's enough interest, and if you're interested, just shoot me an email. I can also record a citation tutorial. But if I do that, it would help me if you would let me know what you're most interested in hearing about, because if I record like an hour, because you're not going to want to watch more than that of citation anyway. If I record it about an hour, there are a lot of different ways I can go with that. I can go very broad and hit a lot of topics, or I can go into depth on a couple of things. Another option is that I can record it so that there are short segments with one topic each, so you're only watching 5 to 10 minutes of exactly what you want. So there are a lot of different ways I can go with that for you, if you'll let me know what you're most interested in. Lorraine.
One of the things I share with my group is that I had an issue with formatting the numbers and like the Roman numerals in the beginning, and then going 1, 2, 3, and even with the dots after. I don't know, what do you call that? The
dot leaders.
Yeah, I couldn't. I was doing it manually, and it was driving me crazy. And I pretty much like Mila, I had to kind of like put it together, and then I think it still got screwed up. So I don't know why I had such a hard time.
So what you're talking about are actually kind of word issues. Yeah. And I have a stock response on word issues, which first of all, I hate Word. I hate it. I've always hated it. It's a crappy application for lawyers to use because it does so much of the formatting automatically, which is great if you don't have specific formatting needs. But lawyers have specific formatting needs, and when we cover the material on visual persuasion, you'll see that your formatting needs to make something not just intellectually persuasive or emotionally persuasive, but also just visually persuasive, you're going to have even more specific needs. And so I use WordPerfect. I use it for everything. I always have. I have it on my laptop. I have it on my machine. I'm the only professor in the building who has WordPerfect, and IT hates me for it, but I don't care. It's great for law. It's fantastic for lawyers. that said, the reason I tell you that is because I'm not super proficient in Word. I can do a lot more with WordPerfect than I can with Word. And in fact, most of the documents that I give my students, especially ones that have tables or charts, those are things that I did in WordPerfect and converted to PDF. So my advice, and this is what I do on Word when I don't know how to do something, the YouTube.
I've
Go to
done
YouTube and search for something. Dot leaders in Microsoft Word. Just type that in. For reasons passing my understanding, there are people whose heart delights to provide YouTube videos of how to do things in Word. And so I have never been disappointed by YouTube when I need to do something in Word. As a nice side benefit, if you do it right before you go to bed, you'll just fall dead asleep. So that's my suggestion. And there are legal ones too for, and I have a friend who did some of the legal ones. I'm like, wow, that is hands down the dorkiest thing you've ever done in your life. But there's one on Table of Authorities, there's one on Table of Contents and appellate briefs. And so that stuff is great. As far as outlining, and labeling, the order is always Roman numerals, capital letters, Arabic numerals, lowercase letters, lowercase Roman. And I'm sure there's something below that, but I've never, your document's dramatically over-organized if you go below that. So that's the order of things. Anytime you need that information, because you'll forget it, and which is perfectly normal. There's a website, the Online Writing Lab. It's OWL OWL at Purdue University. And just type in outlining, and it'll show you that, or just Google outlining, and it'll show you the standard. And it's the same, no matter where you look, that's the standard way to go about that. And, you know, if nothing else, put it on a sticky note and put it on your computer. You're going to use it over and over and over again. So have it someplace handy. I have this vision, maybe I'll do it this summer. I have this vision of putting like all of the things that people forget about legal formatting, but they need to know on a mouse pad. Like that's where you need it, where it's like right there. I have this revision checklist that I use in the power writing. And at one point, the checklist was short enough that I could put the entire checklist on a mouse pad. And it was awesome, but now it's way too long for that. Anyway, so you guys have looked at intelligence as a trait in your own documents. And obviously, it's low-hanging fruit to look at that motion brief that I gave you guys to look at and figure out what traits of intelligence are missing. What I really want to talk about, though, in the time that we have left is what traits does it have? Because it's not actually bad from every single standpoint. It's clearly not great, and there are clearly problems, and it's obvious that the problems ultimately end up carrying the day. But there are also some good things in it. Did you guys notice some of the good stuff in it? Yeah, Loretta. Oh, hold on. Okay, go ahead.
No, sorry. I thought he showed that he was informed about the medical issues.
Mm-hmm.
And he tried to explain to the audience, you know, the different, like, the degrees of range of motion and all of that kind of stuff.
Mm-hmm.
And it seemed like he considered the opposing argument, but then he ruined it for himself by putting in the sarcastic comments.
Yeah. Yeah.
But he did have some positive things in there, but he kind of shot himself in the foot with the other things.
Yeah. Nikki, what did you notice?
I agree with Loretta on what she said. And also, I think that besides from being organized and informed, he was deliberate. He was like, his tone was not the best choice throughout, but he was deliberate in what he was saying, and he was detail oriented, and he knew the law. I think he chose to go in a disrespectful tone, but it's not like he didn't convey the material.
Mm-hmm.
You know what I mean?
Yeah. Rayanne?
I personally thought that I kind of agree with the other two students that he obviously knows what the case is about, and he did try to come across in a way to relay that information to the reader. However, there was a certain level in which he could have taken a sarcastic tone. For instance, I just read a decision today where the lawyer had said that an attorney a competent attorney wouldn't give such advice to their client. And it wasn't going after the attorney directly saying, well, this attorney's really bad and they don't know what their job is, but a competent attorney wouldn't have possibly said it the way that it was relayed. Mm-hmm. So I feel like there was a way to handle it, and there was a point where he just teetered over the edge. He took it too far. And I'm sure it was funny to read, might have had a couple laughs here and there, but there was a certain level where he could have stayed, and I felt like he just went above and beyond that.
Yeah. Any other things you guys noticed that he did well? Any traits of ethos that he did particularly well? I thought his formatting was very clean. There are certainly some things that I would tweak if I were giving him suggestions, but the formatting overall was very clean. The numbered paragraphs are not something you usually do in a brief, but because it was a motion brief, I think that's, in trial court, things are a little bit more flexible, and the numbered paragraphs can be really helpful. I agree that he was deliberate, that he was thorough, that he was, hold on, let me get my whole list here. Oops, hold on. Yeah, so he was informed, he was adept at research, he was organized, he was analytical, he was deliberate, he was empathetic to the reader in that it was well organized and cleanly formatted. It was practical, it was articulate, it was eloquent. It was snarky and mean, but it was eloquent. You got to give him that. The guy can craft an insult. It was detail oriented, and I think the snarkiness was innovative. I think the problem with it is it was innovative, but it completely undercut the character and goodwill. And so, again, like I've said to you guys many times, it's important not to know just whether something's persuasive, although, that is important to know that, but if it's not persuasive, why is it not persuasive? What happened? Where did it go off track? And he hits these traits of intelligence one after the other. He's got all of them. But in that last one, that innovative, in an attempt to do something different that no one else does, he completely cut the legs out from under himself on character and goodwill. So the ethos ultimately failed. The pathos, I think, failed. So, the reason I think clearly that he won the motion was because the logic was there. We'll talk about logic later, but the logic was there, and all of the traits of intelligence were there. I think that's what saved him, was the traits of intelligence, that he did demonstrate all of those. Had he missed on really any of those, I think he would have been completely sunk. But yeah, so that's what's so fascinating to me about this is he nailed intelligence, he nailed logos, and then completely shot himself in the foot with the other stuff. I'll tell you, it's a student of mine who brought this to me. It was her boss wrote it. And she got his permission. She said, can I take this to one of my professors? And he was like, yeah, absolutely, take it. It will surprise you not at all to learn that he was proud of it. He was happy with it. And that even after he'd been sanctioned by the court, he didn't care. He said, I'll do it again. I doubt that he would actually do it again because he got in a little bit of hot water at work. But, yeah, so innovative, you got to be careful. You got to be careful. Any other comments or questions about ethos generally or intelligence specifically? Okay. So again, that's a good place to do some notes about what you'd like to annotate, what you'd like to change in your brief as you go along. Probably it's good, since we've just covered it today, that you want to make a lot of notes maybe this weekend about, even if you don't do the changes, make notes about what you want to change while it's all very fresh, so you can kind of keep the ball moving along. So next week, we will be talking about, hold on, what will we be talking about? So next week, we're talking about logos in legal writing. Specifically, we're going to be talking about rule illustrations, what a lot of people call the rule explanation or the rule proof, and also undercutting opposing argument. So we're going to get into that, those areas of logos. Notice that by June 14th, which is next Tuesday, because we're off the 13th, next Tuesday, you're going to submit one of the argument sections of your brief on which you would like some feedback. And along with that section of your brief, you want to include either an essay or annotations noting the strengths and the weaknesses. So if you want to do the part of the brief that that you guys talked about tonight, and sort of analyze that and get some feedback on that, I'm happy to have you do that. Or you can do a different section if you want to start to diversify a little bit. But the purpose of having you turn this in is so that you can start to get some feedback at the very beginning about whether you're on track with what you're thinking about your document and whether you're drafting those annotations adequately. So my suggestion is to do the annotations rather than an essay, because that's ultimately what you're going to have to draft. And then I can give you some feedback not only on the document, but also on the annotations as you analyze in the document. What else? And that's pretty much it. Okay. I'll see you guys next Tuesday and Wednesday. And have a great weekend. Oh, wait, sorry, you son had a question.
Regarding this assignment, we gotta use 3 traits. I mean, ethos, pathos, another one, right?
Logos. No, you don't have to use all of them. You don't have to use all of them in detail. What I say is use what you've learned so far about ethos, pathos, and logos. So we haven't gone into pathos in a lot of detail. We haven't gone into logos in a lot of detail, so that's fine. But ethos we have gone into in a lot of detail. So yeah, so whatever it is that you notice that you think you either did well or that you think you could change and do better. Keep in mind that the annotations, this assignment counts for 10% of your course grade. And so not only does the document need to be, you need to have done some work on the basic writing and citation and things like that, but I'm also looking for well-written annotations. So the annotations also have to be grammatically correct. Yeah, Lorraine.
Okay, so we all have in our own head our own opinion of what we think this is or that is or how it should be.
Mm-hmm.
So what if we're totally off on, I mean, obviously we can read what it's supposed to be and we have the examples in the book, but what if we're just out to left field or right field and not really on the same page with you?
Then it's going to be so much better to find that out when it only costs you 10% than when it costs you a lot more at the end of the semester. So it's a pretty low impact assignment as far as your grade.
Okay. Well, thanks.
Yeah, Ryan and then Randy.
Quick question: if we're reformatting sentences and things within our essay, should we be, if it's not related to ethos, specifically for that, do we have to like track the changes? Do you want to see what we did, or you just kind of want like a nicer final product, but then identify in the footnote?
I think that's a really good point. I think for this assignment, this 10% assignment, I think that a track changes version would be really helpful. Because then I can definitely see what you did. On the final project, I just want a nice looking brief with the annotations. But I think for this one and the statement of facts that's coming up in a couple of weeks, I think track changes would be really helpful. You don't have to do it if there's somebody who just doesn't want to do track changes, but that would be really helpful, I think.
Okay.
And do yourself a favor, don't put comments in the margins with the bubbles, because you're going to end up having to move those into footnotes later. And so you just make it harder on yourself when you do that. So just drop a footnote for each annotation.
Okay.
The other thing is that I want to respond to that you asked, Ryan, was you said, what if it doesn't relate to ethos, pathos, and logos? It all relates to ethos, pathos, and logos. Every change you make, you're making because it's going to make the document better and more persuasive. So you need to identify what aspect of persuasion that the change is going to improve. Randy.
In terms of the articles that you have us read, is there a certain time that we can expect it to be posted, or?
I'll put for next week. They're all posted. I've got them hidden.
Okay.
Not for any other reason than it's just something I did. So before I leave my office tonight, I'll make sure everything for next week is up. And anytime there's an article listed, that's the actual title of the article. So if you're getting antsy, you can always do a title search in Westlaw or Lexis and come up with the article. There aren't any other articles with these names. Okay, have a great weekend. I will see you guys next week. You're doing great work.
Thank you, Professor. Have a nice weekend.
Thank you, you too. Bye-bye.